for me because of the reason that it is my alma mater. I did my degree, first master degree and second master degree, that is law, and also PhD from Mysore University. Then I worked with Mysore University for 1 year on deputation as the founder director of Mysore University School of Law. And with this, let me go to the topic today. Assigned to me is public interest litigation in this session. What is public interest litigation? Its origin and its use in India, and also how this concept called public interest litigation has transformed the judicial system in the country, and how does it responsible for bringing several changes in the field of administration of justice. This is that I am going to concentrate for 1 hour. Friends, the word itself clearly indicates that it is a public interest litigation. We lawyers always fascinated with the word litigation because without litigation, there is no scope for a lawyer. But here, this is the public interest litigation we are discussing. Before going to have a discussion on public interest litigation, better we to understand the constitutional provisions in India through which we can approach the court of law to get remedy. Perhaps you are all aware of Part 3 of the Indian Constitution, which deals with fundamental rights. There are a good number of fundamental rights guaranteed, among whom the right to equality, right to freedom, then right against exploitation, then comes right to freedom of religion, minorities' right, and right to constitutional remedy. These are all the important rights which are helpful for us to protect our fundamental rights, which are necessary and basic. We consider them as fundamental because of the reason that these are all the rights which are given primacy even in the Constitution itself, which is equivalent to the Bill of Rights in the American Constitution. Friends, these rights, it is a duty on the part of the Supreme Court to protect these rights. That's why we call the Supreme Court is the guarantor of the Constitution, is the guarantor and protector of our fundamental rights. When it comes to Article 32 of the Indian Constitution, which deals with the right to constitutional remedy, Dr. B.R. Ambedkar considered this particular provision as the heart and soul of the Constitution. I may ask you the question like this: which provision of the Constitution is considered as the heart and soul of the Constitution? For each answer should be Article 32, which deals with constitutional remedy. Which means, in case of any violation of our fundamental rights, we can approach directly the Supreme Court under Article 32 of the Constitution and any citizen of India. And when it comes to some of the fundamental rights, even the non-citizen also can approach the Supreme Court under Article 32 directly to get remedy. Then it is the duty of the Supreme Court to protect our fundamental rights. That's why when there was a question asked to Dr. B.R. Ambedkar, can you name any one of the provision in the Constitution without which Constitution become nullity? For which Dr. B.R. Ambedkar answered like this: if I were asked to name any one of the provision without which the Constitution becomes nullity, I have no hesitation to name Article 32 of the Constitution. It is the heart and soul of the Constitution. ಸಂವಿಧಾನದ 32ನೇ ಅನುಚ್ಛೇದ ಏನಿದೆಯೋ ಅದು ಸಂವಿಧಾನದ ಹೃದಯ ಮತ್ತು ಆತ್ಮ ಇದ್ದಂತೆ ಅಂತ ಹೇಳಿ ಡಾಕ್ಟರ್ ಬಿ ಆರ್ ಅಂಬೇಡ್ಕರ್ ಅವರು ಹೇಳ್ತಾರೆ ಇದ್ರ ಬಗ್ಗೆ. ವಾಟ್ ಆರ್ ಆಲ್ the remedy available to a person under Article 32 of the Constitution? Article 32 empowers Supreme Court to pass any order, any judgment, or writs in the nature of habeas corpus, mandamus, certiorari, prohibition, and quo warranto, or any other appropriate proceedings. ಅಲ್ಲಿ 5 ಪ್ರಕಾರವಾದಂತಹ ರಿಟ್ ಅನ್ನ ಅದರಲ್ಲಿ ಹೇಳ್ತಾರೆ. ರಿಟ್ ಆಫ್ ಹೇಬಿಯಸ್ ಕಾರ್ಪಸ್, ರಿಟ್ ಆಫ್ ಮ್ಯಾಂಡಮಸ್, ರಿಟ್ ಆಫ್ ಕೋ ವಾರೆಂಟೋ, ರಿಟ್ ಆಫ್ ಪ್ರೊಹಿಬಿಷನ್ ಮತ್ತೆ ರಿಟ್ ಆಫ್ ಸರ್ಶ್ಯೂರರಿ. ಈ 5 ಪ್ರಮುಖವಾದಂತಹ ರಿಟ್ಸ್ ಗಳನ್ನ ಅದರಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡ್ತಾರೆ. ಐ ಹ್ಯಾವ್ ನೋ ಟೈಮ್ ಟು ಡಿಸ್ಕಸ್ ದ ಇಂಡಿವಿಜುವಲ್ ರಿಟ್ಸ್, ಬಟ್ ಐ ವುಡ್ ಲೈಕ್ ಟು ಗಿವ್ ಯು I would like to impress upon you the importance of these writs. Number 1, writ of habeas corpus, which deals with anyone can approach the court of law under Article 32, that is directly to the Supreme Court, requesting the Supreme Court to order to the law enforcing agency or appropriate investigating body to produce a person who is illegally detained or arrested or his whereabouts are not known. ಯಾವುದೇ ಒಬ್ಬ ವ್ಯಕ್ತಿಯನ್ನ ಕಾನೂನಿನ ಪ್ರಕಾರ ಬಂಧಿಸಲ್ಪಟ್ಟಿಲ್ಲದೆ ಆತನ ಅಕ್ರಮ ಬಂಧನದಲ್ಲಿ ಇಟ್ಟಿದ್ದಂತ ಸಂದರ್ಭದಲ್ಲಿ ಆತನನ್ನ ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಹಾಜರುಪಡಿಸಿ ಅಂತ ಹೇಳಿ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯ ನೀಡ್ತಕ್ಕಂಥ ಆದೇಶವನ್ನೇ ನಾವು ರಿಟ್ ಆಫ್ ಹೇಬಿಯಸ್ ಕಾರ್ಪಸ್ ಅಂತ ಕರಿತೀವಿ. ಟು ಪ್ರೊಡ್ಯೂಸ್ ದ ಬಾಡಿ ದೇರ್ ಆಫ್, ದಟ್ ಮೀನ್ಸ್ ಹೇಬಿಯಸ್ ಕಾರ್ಪಸ್ ಮೀನ್ಸ್ ಟು ಪ್ರೊಡ್ಯೂಸ್ ದ ಬಾಡಿ ದೇರ್ ಆಫ್. Mandamus means it is a direction issued by the court to the statutory authority, constitutional authority, local authorities, or any of them to do something and not to do something. It is called as a mandamus. That means, in other way, we call it as direction, a command of the Supreme Court to direct other authorities to do something and not to do something. ಯಾವುದೇ ಒಂದು ಸಂವಿಧಾನ ಬದ್ಧವಾಗಿ ಇರ್ತಕ್ಕಂತಹ ಒಂದು ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಆಗಿರ್ಬೋದು, ಅಥವಾ ಕಾನೂನು ಪ್ರಕಾರವಾಗಿ ರಚನೆ ಆಗಿರ್ತಕ್ಕಂಥವಾಗಿರ್ಬೋದು, ಲೋಕಲ್ ಸೆಲ್ಫ್ ಗವರ್ಮೆಂಟ್ ಆಗಿರ್ಬೋದು, ಅಂಥವ್ರಿಗೆ ಇದನ್ನ ಮಾಡಿ ಅಥವಾ ಇಂಥದ್ದನ್ನ ಮಾಡಬೇಡಿ ಅಂತ ಹೇಳಿ ಕೊಡ್ತಕ್ಕಂಥ ನಿರ್ದೇಶನ ಇದೆಯಲ್ಲ, ಅದನ್ನ ನಾವು ಮ್ಯಾಂಡಮಸ್ ಅಂತ ಕರಿತೀವಿ. ಅದಕ್ಕೆ ನಾವು ಅದನ್ನ ಕಮಾಂಡ್ ಅಂತ ಕರೆಯೋದು. ನಂತರ certiorari ಅಂತಂದ್ರೆ to quash, its meaning is quash, which means any decision taken by any authority, any body, constitutional, statutory, or any other bodies. The court can issue a writ of certiorari to quash the decision. ಯಾವುದೇ ಒಂದು ನ್ಯಾಯಾಲಯ ಆಗಿರಬಹುದು ಅಥವಾ ಯಾವುದೇ ಒಂದು ಕ್ವಾಸಿ ಜುಡಿಷಿಯಲ್ ಅಥಾರಿಟಿ ಅಥವಾ ಅರೆ ನ್ಯಾಯಿಕ ವ್ಯವಸ್ಥೆ ಅಂತ ಕರಿತೀವಲ್ಲ, ಟ್ರಿಬ್ಯುನಲ್ಸ್ ಅಂತ ಹೇಳ್ತಾರೆ ನೋಡಿ, ಅವರು ಕೊಟ್ಟಿರ್ತಕ್ಕಂಥ ಯಾವುದೇ ತೀರ್ಪುಗಳನ್ನು ಅನೂರ್ಜಿತಗೊಳಿಸ್ತಕ್ಕಂತಹ ಅಧಿಕಾರ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇರ್ತಕ್ಕಂಥದ್ದು. ಪ್ರೊಹಿಬಿಷನ್ ಮೀನ್ಸ್ ಯು ಸ್ಟಾಪ್, ಡೋಂಟ್ ಪ್ರೊಸೀಡ್ ಈಸ್ ಕಾಲ್ಡ್ ಆಸ್ ರಿಟ್ ಆಫ್ ಪ್ರೊಹಿಬಿಷನ್. ಅಂಡ್ ಅಟ್ ಲಾಸ್ಟ್, ಎನಿ ಒನ್ ಕ್ಯಾನ್ ಕ್ವಶನ್, an Indian citizen can question the appointment of a person who is not qualified to any of the public post. That is called writ of quo warranto. In case if it is a public office, for that public office, a person who is not eligible is being appointed by the competent authority. Anyone can question it, and the court can issue writ of quo warranto stating that you have no eligibility, you relinquish your office, you get out, you quit. That is called quo warranto. Okay, these are broadly the 5 writs are normally issued by the Supreme Court under Article 32, and under Article 226. The same power is vested with the high courts. ಸಂವಿಧಾನದ 226ನೇ ವಿಧಿಯ ಅನ್ವಯ ಹೈಕೋರ್ಟ್ಗೂ ಸಹ ಇದೇ ರೀತಿಯಾದಂತ ಅಧಿಕಾರವನ್ನ ನಾವು ಕೊಟ್ಟಿದ್ದೀವಿ. ಆದ್ರೆ that is not a fundamental right. Part 3 of the Constitution is from Article 12 to 35. Then Article 32 itself is a fundamental right. We can approach the Supreme Court, but whereas in case of Article 226, even though you approach the High Court, that cannot be claimed as a matter of right. It is the discretion of the High Court whether it can allow your writ or not. At least under Article 32, the Supreme Court is duty bound to listen to us. When you knock the doors of the Supreme Court stating that my fundamental rights are being violated, then the Supreme Court has no other alternative. It has to entertain your writ. At least it has to listen to you. That's why we call Article 32 as the heart and soul of the Constitution. Now, another important question arises is this. Who can approach the court of law to get remedy is the question. Who can approach court of law? Normally, a person, one who is aggrieved, can only approach court of law. ಯಾರು ನ್ಯಾಯಾಲಯಕ್ಕೆ ನ್ಯಾಯಾಲಯದಿಂದ ಪರಿಹಾರಕ್ಕಾಗಿ ನ್ಯಾಯಾಲಯವನ್ನ ಅಪ್ರೋಚ್ ಮಾಡ್ಬೋದು ಅಂತಂದ್ರೆ ಯಾರು ತೊಂದರೆ ಆಗಿರ್ತಾನೋ ಆ ವ್ಯಕ್ತಿ ಮಾತ್ರ ಅಪ್ರೋಚ್ ಮಾಡಬೇಕು. ಅದಕ್ಕೆ ಲೀಗಲ್ ನಲ್ಲಿ ಒಂದು ಕಾನ್ಸೆಪ್ಟ್ ಇದೆ. ಅದಕ್ಕೆ ನಾವೇನಂತೀವಿ ಅಂದ್ರೆ ಲೋಕಸ್ ಸ್ಟ್ಯಾಂಡೈ ಅಂತ ಕರಿತೀವಿ. LOCUS, locus, STANDI, locus standi. This is a Latin term. The locus standi means the authority to stand. ನಾವು ಹೆಚ್ಚಿನ ಜನ ಕನ್ನಡದವರು ಕರ್ನಾಟಕದವ್ರು ಇರೋದ್ರಿಂದ ನಾನು ಈ ಪದ ಬಳಸಿದ್ರೆ ಸರಿ ಹೋಗುತ್ತೆ ಅಂತ ಅನ್ಕೋತೀರಿ. ನಾವು ಯಾವುದೇ ಒಂದು ಊರುಗಳಲ್ಲಾಗ್ಲಿ ಸಣ್ಣದಾಗ್ಲಿ ಒಂದು ಕುಂಟೆ ಜಮೀನಿಗೆ ಅಥವಾ ಯಾವ್ಯಾವ್ದಕ್ಕೂ ಅವ್ರು ಜಗಳ ಮಾಡ್ತಾ ಇದ್ರೆ ಅವ್ರು ಜಗಳ ಮಾಡುವಂತ ಕೇಳ್ತಾನವನು, ಏನ್ ನಿಮ್ಮ ಅಪ್ಪನ ಮನೆ ಆಸ್ತಿ ಇದ್ದದ ಇಲ್ಲಿ, ನಿನ್ಗೇನು ಅಧಿಕಾರ ಇದೆ, ನೀನೇನ್ ಕೇಳ್ತಾ ಇದ್ದೀಯಾ ಅಂತನಲ್ಲ. ಅದನ್ನೇ ಲೋಕಸ್ ಸ್ಟ್ಯಾಂಡೈ ಅನ್ನೋ ಪದ ಹೇಳೋದು. ದ ಲೋಕಸ್ ಸ್ಟ್ಯಾಂಡೈ ಮೀನ್ಸ್ ಇನ್ ವಾಟ್ ಕೆಪಾಸಿಟಿ ಯು ಆರ್ ಅಪಿಯರಿಂಗ್ ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್ ಆಫ್ ಲಾ. Do you have any reason to approach this court of law? By what authority you are approaching court of law is called as locus standi. ಅದನ್ನ ನಾವು ಲೋಕಸ್ ಸ್ಟ್ಯಾಂಡೈ ಅಂತ ಕರೆಯೋದು. ಈಗ ಇದನ್ನ ಗಮನದಲ್ಲಿ ಇಟ್ಟುಕೊಂಡು ನಾರ್ಮಲಿ an aggrieved person can approach court of law, but sometime even a person who is not directly aggrieved by the decision of an administrative authority, or a person who is not directly aggrieved by a law passed by the competent authority, that is either parliament or the state legislature, or through a subordinate legislation by a state government or the Union of India, or any decision taken by the local authority. In such circumstances, that person representing other similarly placed persons can approach court of law to get remedy. That is called public interest litigation. Which means a person who is representing others, a section of people or a group of people, those who are similarly placed and aggrieved by a particular law or by an administrative action or by the decision taken by any authority against which he can approach court of law representing others. That is called public interest litigation. ಯಾವುದೇ ಒಬ್ಬ ವ್ಯಕ್ತಿ ಯಾವುದೇ ಒಂದು ಕಾನೂನಿನ ಪ್ರಶ್ನೆಯನ್ನ ಎತ್ತೋದಾದ್ರೆ, ಅಂದ್ರೆ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಾಲಿಟಿ ಆಫ್ ಎ ಲೆಜಿಸ್ಲೇಷನ್, ಅದನ್ನ ಕ್ವಶನ್ ಮಾಡೋದಾದ್ರೆ, ಯಾವುದೇ ಒಂದು ಆಡಳಿತ ಅಂಗ ತೆಗೆದುಕೊಂಡಿರ್ತಕ್ಕಂಥ ನಿರ್ಧಾರವನ್ನ ಪ್ರಶ್ನೆ ಮಾಡ್ತಕ್ಕಂಥ ಸಂದರ್ಭದಲ್ಲಿ he can represent the whole group. That's why we have a provision in CPC, in ordinary law, that is Civil Procedure Code, Order 1, Rule 8, which deals with representative suit. ಯಾವುದೇ ಒಂದು ಕೆಳ ನ್ಯಾಯಾಲಯದಲ್ಲಿ, ಯಾವುದೇ ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಯಾವುದೇ ಒಬ್ಬ ವ್ಯಕ್ತಿ ತನ್ನ ಊರಿನ ಪರವಾಗಿ, ತನ್ನ ಜನಗಳ ಪರವಾಗಿ ಕೆಳ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಹೋಗಿ ಅಲ್ಲೂ ಕೂಡ ರೆಮಿಡಿ ಪಡ್ಕೊಳ್ತಕ್ಕಂಥ ಒಂದು ಪ್ರಾವಿಷನ್ ಇರೋದನ್ನ ನಾವು ನೋಡಬಹುದು. ಇದೆ, CPC ನಲ್ಲಿ ಇದೆ. ಬಟ್ ವೆನ್ ಇಟ್ ಕಮ್ಸ್ ಟು ದಿ ಪ್ರೊಟೆಕ್ಷನ್ ಆಫ್ ಫಂಡಮೆಂಟಲ್ ರೈಟ್ಸ್, then it is the power vested with the High Courts under Article 226 and to the Supreme Court under Article 32 to entertain public interest litigation and to pass appropriate orders and to give appropriate remedy to the concerned person. Now, the word locus standi is liberalized when it comes to the public interest litigation. ನಿಮಗೆ ಒಂದೇ ಸಿಂಪಲ್ ಆಗಿ ಹೇಳ್ಬೇಕಂತ ಹೇಳಿದ್ರೆ, ಈಗ ಉದಾಹರಣೆಗೆ ನಮ್ಮ ಯಾವುದೋ ಒಂದು ಆಸ್ತಿನ ಬೇರೆಯವರು ಅತಿಕ್ರಮಣ ಮಾಡಿದ್ದಾರೆ ಅಂತಂದ್ರೆ ನಾನು ಮಾತ್ರ ಹೋಗಿ ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಪರಿಹಾರ ಪಡ್ಕೊಳ್ಳೋಕೆ ಸಾಧ್ಯ, ಬಿಕಾಸ್ ಐ ಆಮ್ ದ ರಿಯಲಿ ಅಗ್ರೈವ್ಡ್ ಪರ್ಸನ್. ಅಲ್ಲಿ ಅಂಥ ಸಂದರ್ಭಗಳಲ್ಲಿ ಪಬ್ಲಿಕ್ ಇಂಟ್ರೆಸ್ಟ್ ಲಿಟಿಗೇಷನ್ ಅಂತ ಪದ ಬರೋದಿಲ್ಲ. ಆದ್ರೆ ಎಲ್ಲಿ ಹೆಚ್ಚಿನ ಜನಗಳಿಗೆ ಯಾವುದೋ ಒಂದು ನಿರ್ಧಾರದಿಂದ, ಯಾವುದೋ ಒಂದು ಶಾಸನದಿಂದ, ಯಾವುದೋ ಒಂದು ಸರ್ಕಾರಿ ಆದೇಶದಿಂದ ಆಗಿರ್ತಕ್ಕಂಥ ತೊಂದರೆನ ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡೋದಿದೆಯಲ್ಲ, ಇಡೀ ಸಮಾಜವನ್ನ ಅಥವಾ ಒಂದು ಗುಂಪಿನ ಜನವನ್ನ ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡೋದಿದೆಯಲ್ಲ, ಅದಕ್ಕೆ ನಾವು ಪಬ್ಲಿಕ್ ಇಂಟ್ರೆಸ್ಟ್ ಲಿಟಿಗೇಷನ್ ಅಥವಾ ಸಾರ್ವಜನಿಕ ಹಿತಾಸಕ್ತಿ ಮೊಕದ್ದಮೆಗಳು ಅಂತ ಕರಿತೀವಿ. ಫ್ರಮ್ ವೇರ್ ಡಿಡ್ ವಿ ಗೆಟ್ ದಿಸ್? ಎಲ್ಲಿಂದ ಇದು ಬಂದಿದೆ, ನಾವು ತಗೊಂಡಿದ್ದೀವಿ ಅಂತಂದ್ರೆ, ಇನ್ ಯುನೈಟೆಡ್ ಸ್ಟೇಟ್ಸ್ ಆಫ್ ಅಮೆರಿಕಾ they call it as social action litigation. Social action litigation. Here in India, we call it as public interest litigation. In America, whereas they call it as social action litigation. That social action litigation in which any public spirited person, in law, in a legal terminology, we call it as pro bono publico. A person, one who is interested in the public interest, he can approach court of law to get remedy. That is the concept called public interest litigation. In case, if there is no public interest litigation, what happens? It would resulted in several complications. Like what? If you strictly adhere to only the person aggrieved can approach court of law, then most of the public problems may not be get addressed by the highest constitutional court, that is the Supreme Court or the high courts. In such circumstances, it is a useful tool in the hands of people, those who are public spirited or pro bono publico, which means those who work for the benefit of the public, general public, or the society at large. It is a tool in their hand to bring it to the notice of the court, that is the administrative malaise or maladministration. In other words, the nepotism in public administration and passing of a legislation which is grossly violate the people's fundamental right. Then in such circumstances, there are two important reasons behind the popularity of this public interest litigation. ಒಂದು ವೇಳೆ ಪಬ್ಲಿಕ್ ಇಂಟ್ರೆಸ್ಟ್ ಲಿಟಿಗೇಷನ್ ಇಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಆಗ್ತಾ ಇತ್ತು ಅಂತ ನಾವು ಯೋಚನೆ ಮಾಡೋದಾದ್ರೆ, ಅದಕ್ಕೆ ನಾನು ಎರಡು ಕಾರಣವನ್ನ ಪ್ರೊಫೆಸರ್ SP ಜೈನ್ ಅಂಡ್ ಜೈನ್ ಪ್ರಿನ್ಸಿಪಲ್ಸ್ ಆಫ್ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಲಾ ಪುಸ್ತಕದಲ್ಲಿ ತುಂಬಾ ಚೆನ್ನಾಗಿ ವರ್ಣನೆ ಮಾಡ್ತಾರೆ ಅವರು. ಅಕಾರ್ಡಿಂಗ್ ಟು ದೆಮ್, ಇಫ್ ದೇರ್ ಇಸ್ ನೋ ದಿಸ್ ಟೈಪ್ ಆಫ್ ಪಬ್ಲಿಕ್ ಇಂಟ್ರೆಸ್ಟ್ ಲಿಟಿಗೇಷನ್, ದೆನ್ the larger public interest would not have been taken to the doors of the Supreme Court. Take for example, in case of environment pollution, air pollution, water pollution, sound pollution, in such circumstances, we are not directly affected, but large number of people are affected. Any person, one person can represent that group and he can litigate it before the court of law, isn't it? Then ನಾವು ಪರಿಸರಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತ ವಿಷಯಗಳಿಗೆ ಬಂದ್ರೆ, ಡೈರೆಕ್ಟ್ ಆಗಿ ನನಗೇನಾದ್ರೂ ಲಾಸ್ ಆಗಿದೆಯಾ ನೇರವಾಗಿ ಅಂತ ಕೇಳಿದ್ರೆ ಪ್ರೂವ್ ಮಾಡೋಕ್ಕಾಗೋದಿಲ್ಲ. ಬಟ್ ಇಟ್ ಈಸ್ ಎ ಲಾಸ್ ಟು ದ ಹೋಲ್ ಸೊಸೈಟಿ. ದೆನ್ ಇನ್ ಸಚ್ ಸರ್ಕಮ್ಸ್ಟೆನ್ಸ್, ಪ್ರದೀಪ್ ಕುಮಾರ್ ಪ್ಲೀಸ್ ಮ್ಯೂಟ್ ಮಾಡಿ. Pradeep Kumar, please mute Madi, sir. Yes. Now, if you see, there the large number of people get affected by that. In such circumstances, any one who is interested, he can.
ನಾನು ಮಚ್ ಇಂಟ್ರೆಸ್ಟೆಡ್ ಸರ್. ಖುಷಿಯಿಂದ ಆರಾಮ ಡ್ಯೂಟಿ ಮಾಡ್ತಿದ್ದಲ್ಲಿ. ಆಮೇಲೆ ಅಲ್ಲಿ ನೋಡಿ ಸರ್, ಒಬ್ಬ ಡಿಸಿಪ್ಲಿನ್
Okay. Anyone can represent the whole group through filing a public interest litigation before court of law. This is one reason. The second important thing is that in country like India, where the poverty is rampant and illiterate people are more, and also approaching court of law is becoming costlier day by day, then how can a common man, a penniless common man, approach court of law to get remedy? ಈಗಾಗಲೇ ನಮಗೆ ನಿಮ್ಗೆಲ್ಲರಿಗೂ ಗೊತ್ತಿರೋ ಹಾಗೆ ಕೋರ್ಟ್ಗೆ ಹೋಗೋದು ಅಂತಂದ್ಬಿಟ್ಟಂದ್ರೆ ಅಲ್ಲಿ ಒಂದು ಗಾದೆ ಇದೆ, ಕೋರ್ಟ್ಗೆ ಹೋದ್ರೆ ಗೆದ್ದೋನ್ ಸೋತೋನ್ ಸತ್ತ ಅಂತ ಹೇಳಿ. ಹಾಗಾಗಿ ಅದು ಕಾಸ್ಟ್ಲಿಯರ್ ಕೂಡ, ತುಂಬಾ ಖರ್ಚು ಕೂಡ ಆಗುತ್ತೆ. ಅಂತ ಸಂದರ್ಭಗಳಲ್ಲಿ ಬಡ ಜನರು ಹೇಗೆ ಬಂದು ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ನಿಂತು ಪರಿಹಾರವನ್ನ ನಿರೀಕ್ಷೆ ಮಾಡೋಕ್ ಸಾಧ್ಯ? ಹಾಗಾಗಿ ಎ ಪರ್ಸನ್ ಒನ್ ಹೂ ಇಸ್ ಪಬ್ಲಿಕ್ ಸ್ಪಿರಿಟೆಡ್ ಕ್ಯಾನ್ ರೆಪ್ರೆಸೆಂಟ್ ಸಚ್ ಹ್ಯಾಪ್ಲೆಸ್ ಪೀಪಲ್ to get remedy from the court of law. Then taken that into consideration, friends, quickly I will move on to one important observation made by Justice Krishna here in one of the important case, that is Fertilizer Kamgar Union versus Union of India, decided in 1981. In that case, how beautifully he put it across. He is of the opinion that if a poor man, a laborer, could not allow to question winding up of a company, then that person is denied justice. Normally, where there is a company applied for closing down, we call it as winding up of a company, where there are many other people, the stakeholders are there, their concerns have to be addressed. Number one, creditors. ಯಾರು ಮೊದಲು ಸಾಲ ಕೊಟ್ಟಿರ್ತಾರೋ ಅವರ ಇಂಟ್ರೆಸ್ಟ್ ನ ಗಮನದಲ್ಲಿ ಇಟ್ಕೋಬೇಕು ಕಂಪನಿ ಕ್ಲೋಸ್ ಆಗೋಕ್ಕಿಂತ ಮುಂಚಿತವಾಗಿ. ಎರಡನೇದು, ಶೇರ್ ಹೋಲ್ಡರ್ಸ್, ಅವರ ಇಂಟ್ರೆಸ್ಟ್ ನ ನಾವು ನೋಡಬೇಕು. ದೆನ್ ಇಫ್ ಯು ಗೋ ಆನ್ ಗಿವಿಂಗ್ ದಟ್ maximum amount to the creditors and the shareholders, then what about the poor worker working in a factory and depending purely on the working condition, depending on that particular factory, he is working as a labor in that particular company. If that company closed down, he will have no work. He will have no work means he has no money for his livelihood. Then in such circumstances, Justice Krishna here is of the opinion that this traditional concept called only aggrieved person can approach court of law sometimes cause damage. Hence, he considered liberalization of locus standi is the need of the hour and held that the public interest litigation should be the order of the day. Then he encouraged the public spirited people to approach court of law. Then under what basis you approach court of law? Number one, friends, the standing includes the notional injury. Number one is the notional injury. It is not necessary it is going to affect you directly. Even it affects you to a certain extent, then you can approach court of law to get remedy. Take for example, I am a resident of Bangalore city. If Bangalore City Corporation comes out with irrational policies, can I not question it before the court of law? Because my money, I am the taxpayer. Being a taxpayer, I do not want my money to go waste and spend unnecessarily on something which is not at all relevant. Agagi, you are a taxpayer, that itself is sufficient that cause you notional injury. Please, I would like to impress upon you with the help of one more case, where in Guruvayur temple, the temple authorities, they changed the process of performing puja to Guruvayur Krishna in that temple. Krishna temple allirodu. ದೇವ್ರಿಗೆ ಪೂಜೆ ಮಾಡಿದ್ರೇನು, ಯಾವ ತರ ಪೂಜೆ ಮಾಡಿದ್ರೇನು, ನಿನಗೇನ್ ತೊಂದರೆ ಆಗುತ್ತೆ ಅಂದ್ರೆ, one person questioned it before the court of law that the temple trust has taken a decision to deviate from age-old practice of performing puja in a particular way. ಅಪ್ಪ ಕಾಲದಿಂದ ತಾತ ಮುತ್ತಾತರ ಕಾಲದಿಂದ ಈ ತರ ಪೂಜೆ ಮಾಡ್ತಾ ಇದ್ರು, ನೀವು ಅದನ್ನ ಬದಲಾವಣೆ ಮಾಡಿದಿರಿ. ಸರಿ, ಬದಲಾವಣೆ ಮಾಡಿದ್ರೆ ನಿನಗೇನಯ್ಯ ನಷ್ಟ ಆಯ್ತು ಅಂತಂದ್ರೆ, ದಟ್ ಇಸ್ ದ ನೋಷನಲ್ ಇಂಜುರಿ ಕಾಸ್ಟ್ ಟು ಮೀ. ಐ ಆಮ್ ಅಟ್ಯಾಚ್ಡ್, ಐ ಆಮ್ ಎ ಡಿವೋಟಿ, that causes injury to me, isn't it? That is called notion, but it is not an actual injury. It is called as notional injury. Second important concept is public duties standing. You are a public authority. You are bound to discharge some duties. Failure on your part to discharge your duty. Being a taxpayer, it is my right to question it before the court of law through appropriate remedy, and court can hear my matter and direct you to do so. Very important case decided in the year 1980 was Ratlam municipality case, where in Ratlam municipality, in one of the states, I think it is in Madhya Pradesh, where the municipal authorities, they collect tax, but there was no proper sanitization, no sewage plants have been built, and where the underground the drainage system was also not proper. Then there was a stagnation of filthy water, which resulted in spread of some communicable diseases. Then a person approached Supreme Court under Article 32, filed a public interest litigation stating that it is the duty on the part of the local authority to provide me facility. The failure of which the Supreme Court issued notice and directed the authorities to take immediate measures. Then it is the public duty on the part of that authority. Failure to do so, then they are liable to discharge their duty properly. In this case, the Supreme Court held that failure to maintain roads and sanitary facilities in the town is amounting to dereliction of duty. Then the authorities were directed to take up such issues on priority basis, and they followed it also. Then the third important thing, that class standing. We were discussing something about it. Class standing means what? You are all newly recruited teachers by various state governments at various level for various posts, but you have been appointed in a single notification. If that notification causes any injustice to anybody or group of people, it is not necessary that all of you have to go and file a writ before court of law. Anyone from your side can approach court of law and file a public interest litigation questioning the decision taken by the administrative authority, or anything wrong committed by the administrative authority. Anyone from your group can approach court of law because he is representing the whole class. I would like to impress upon you with the help of decided cases, the famous cases, that is Sunil Batra versus Delhi administration. In this case, Sunil Batra was an inmate in the jail. He was an inmate in the jail. He was sentenced to punishment. He was undergoing sentence in the jail. That person filed a public interest litigation before the court of law, exposing the unhealthy and unsatisfactory and inhuman condition of jail, the Tihar jail. He had written a letter, a postcard he had taken, and he had written a letter to the Chief Justice of India. Chief Justice of India treated that particular letter as a litigation, and it was treated as a public interest litigation, and the authorities concerned were summoned to file affidavit. ಇವನು ಇಷ್ಟೇ ಮಾಡಿದ್ದು, ಯಾರೋ ಇವನು ನೋಡಕ್ ಬಂದವ್ರ ಹತ್ರ ಒಂದು 25 ಪೈಸೆದ ಒಂದು ಪೋಸ್ಟ್ ಕಾರ್ಡ್ ತರಿಸ್ಕೊಂಡ, ಅದ್ರ ಮೇಲೆ ಒಂದು ಲೆಟರ್ ಬರೆದು ಹೇಗೆ ತಿಹಾರ್ ಜೈಲ್ನಲ್ಲಿ ಇನ್ಹ್ಯೂಮನ್ ಕಂಡೀಷನ್ಸ್ ಇದೆ, ಇಲ್ಲಿ ನಮ್ಮನ್ನ ಸರಿಯಾದ ರೀತಿನಲ್ಲಿ ಟ್ರೀಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ ಅಂತ ಅನ್ನೋದ್ರ ಬಗ್ಗೆ ಒಂದು ಲೆಟರ್ ಬರೆದು ಹಾಕ್ದ ಅಷ್ಟೇ. This is called as epistolary jurisdiction. A letter written to the court of law may also be treated as a writ or a public interest litigation by the court of law is called as epistolary jurisdiction. ನಾವು ಅದನ್ನ ಎಪಿಸ್ಟಾಲರಿ ಜೂರಿಸ್ಡಿಕ್ಷನ್ ಅಂತ ಕರಿತೀವಿ. ಹೀಗೆ ಬರೆದಂತ ಲೆಟರ್ನ ದ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಟ್ರೀಟೆಡ್ ಇಟ್ ಆಸ್ ಎ ರೇಟ್. And then Supreme Court issued notice to the jail superintendent to file an affidavit, and the Supreme Court in fact constituted a committee. That committee visited Tihar jail and submitted report to the Supreme Court that there was no proper facility to the inmates because our jails are overcrowded. ಅದ್ರ ಕೆಪಾಸಿಟಿ 1,000ನೋ 2,000ನೋ ಇನ್ಮೇಟ್ಸ್ ನ ಇಟ್ಕೊಳ್ಳುವಷ್ಟು ಕೆಪಾಸಿಟಿ ಇದ್ರೆ ನಮ್ಮ ಜೈಲಲ್ಲಿ ನಾವು ತುಂಬಿರೋದು 5,000 ತುಂಬಿರ್ತೀವಿ. ಹಾಗಾಗಿ ಈ ತರ ಪರಿಸ್ಥಿತಿ ಇರೋದ್ರಿಂದ there was no proper sanitation, there was no proper facilities being provided to inmates in the jail, and the court directed authorities concerned to provide the facilities to them. That is, it is the class representation. Got the point? That person is not in his individual capacity, he is representing the whole inmates in the Tihar jail. Likewise, even in fertilizers Kamgar Union case I have already mentioned, where in case of winding up of a company, the workers also have to be given opportunity. They have to be, at least they have to be heard as per the Supreme Court decision. In this case, Justice O. Chinnappa Reddy has taken a clue from Shakespeare's drama. In one of the dramas of the Shakespeare, the dialogue was this: you take my life when you do take the means whereby I live. I repeat, you take my life when you do take the means whereby I live. Which means if you take away my means of livelihood, it amounting to take away my life itself. That is the gist of the dialogue. Then here in this case, the Justice Reddy, O. Chinnappa Reddy, he quoted this thing and he held that the laborers, they are not invested their money there, but they have invested their sweat and toil. You remember, the workers invest their sweat and toil and in fact their life itself. ಅವರು ಕೇವಲ ತಮ್ಮ ಏನು ಬೆವರು ಸುರಿಸಿ ದುಡಿತಾ ಇರೋದು ಅಷ್ಟೇ ಅಲ್ಲ, ಅವರು ತಮ್ಮ ಜೀವನವನ್ನೇ ಅಲ್ಲಿ ಮುಡುಪಾಗಿಟ್ಟಿರ್ತಾರೆ ಅದಕ್ಕೆ. ಹಾಗಾಗಿ ದೇರ್ ಇಂಟ್ರೆಸ್ಟ್ ನೀಡ್ ಟು ಬಿ ಪ್ರೊಟೆಕ್ಟೆಡ್. ಹಿಯರ್ ಎನಿ ಒನ್ ಆರ್ಗನೈಸೇಷನ್ ಆರ್ ಎನಿ ಒನ್ ಪರ್ಸನ್ ಕ್ಯಾನ್ ರೆಪ್ರೆಸೆಂಟ್ ದಟ್ ಕ್ಲಾಸ್ ಆಫ್ ದ ಪೀಪಲ್, those who cannot approach court of law. And fourth important point is the public concern standing. The public concern standing is very, very important. Friends, let me tell you, because I know it is an afternoon session. After having lunch, it is very difficult for you people to sit in front of your mobile or the laptop and to spend time hearing. It is only one-sided. Whereas in case of offline classes, we could have interact each other. But now the problem is only after I complete my lecture, then only you will be given an opportunity to raise question. ಸ್ವಲ್ಪ ಇದು ಗೊತ್ತಾಗುತ್ತೆ ನನಗೆ. ಊಟ ಮಾಡಾದ್ಮೇಲೆ ಪಾಠ ಮಾಡೋದು ಕಷ್ಟನೇ. ಈಗ ನೀವು ಹೋಗ್ತೀರಾ, ನೀವೆಲ್ಲರೂ ನೆಕ್ಸ್ಟ್ ಪಾಠ ಮಾಡೋಕೆ ಹೋಗ್ತೀರಾ, ನಿಮಗೂ ಅದು ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಆಗುತ್ತೆ. ಮಧ್ಯಾಹ್ನ ಸೆಷನ್ ತಗೋಬೇಕು ಅಂತಂದ್ರೆ ಅದರಂತ ಪನಿಷ್ಮೆಂಟ್ ಮೇಸ್ಟ್ರಿಗೆ ಇನ್ಯಾವುದೂ ಇಲ್ಲ. ನಿಮ್ಗೆ 2 ಕೆಲಸ ಅಲ್ಲಿ, ಬರೀ ಪಾಠ ಮಾಡೋದಲ್ಲ, ಮಲಗಿರೋರ್ನ ಏಳ್ಸಿ ಪಾಠ ಮಾಡೋದು. ಹಾಗಾಗಿ ಮಲಗಿರೋರ್ನ ಏಳ್ಸಿ ಪಾಠ ಮಾಡೋದನ್ನ ಕಲ್ತ್ಕೋಬೇಕು ನೀವು. ಅದಕ್ಕೆ ದೀಸ್ ಟೈಪ್ ಆಫ್ ಓರಿಯಂಟೇಶನ್ ಕೋರ್ಸ್ ಅಂಡ್ ಫ್ಯಾಕಲ್ಟಿ ಡೆವಲಪ್ಮೆಂಟ್ ಕೋರ್ಸ್ ಸರ್ಟನ್ಲಿ ವಿಲ್ ಹೆಲ್ಪ್ ಯು ಟು ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ದ ಪ್ಲೈಟ್ ಆಫ್ ಯುವರ್ ಸ್ಟೂಡೆಂಟ್ಸ್ ಇನ್ ದ ಕ್ಲಾಸ್ ರೂಮ್ ಅಲ್ವಾ. ನಾವೇನೋ 1 ಗಂಟೆ ಪಾಠ ಬಂದ್ಬಿಡ್ತೀವಲ್ರಿ, ಆದ್ರೆ ನಮ್ಮ ಪಾಠ ಕೇಳೋಕೆ ಅವರು ಎಷ್ಟು ಕಷ್ಟ ಆಗುತ್ತೆ, ಎಷ್ಟು ನೋವು ಅನುಭವಿಸ್ತಾ ಇರ್ತಾರೆ ಅಂತ ನಮಗೆ ಗೊತ್ತಾಗೋದು ಯಾವಾಗ ಅಂದ್ರೆ ಈ ತರ ಓರಿಯಂಟೇಶನ್ ಪ್ರೋಗ್ರಾಮ್ಗೋ ಇಲ್ಲ ಫ್ಯಾಕಲ್ಟಿ ಡೆವಲಪ್ಮೆಂಟ್ ಪ್ರೋಗ್ರಾಮ್ಗೋ ನಿಮ್ಗೆ ಬೆಳಿಗ್ಗೆ ಸಂಜೆ ತನಕ ಕೂರಿಸಿದಾಗ ಗೊತ್ತಾಗೋದು. ಅದಕ್ಕೆ we have to learn how to make our lecture interesting. That's why you always go to the classroom with reading lots of literature. This is my sincere appeal to you, because I am in the verge of retirement. In another 1.5 to 2 years, I will not be there in this field. I will go and wear my black coat and practice before court of law. That is the advantage I have. ನೀವು ಈಗ ಮತ್ತೆ ಈ ಫೀಲ್ಡ್ಗೆ ಬರ್ತಾ ಇರ್ತಕ್ಕಂಥವ್ರು, ನನ್ನ ಸಿನ್ಸಿಯರ್ ಅಪೀಲ್ ನಿಮ್ಗೆ ಎಲ್ಲರಿಗೂ ಏನು ಅಂತಾರೆ, ಆದಷ್ಟು ಲಿಟ್ರೇಚರ್ ಓದಿ. ವೆದರ್ ಯು ಆರ್ ಎ ಟೀಚರ್ ಆಫ್ ಮ್ಯಾಥಮೆಟಿಕ್ಸ್, ಕಾಮರ್ಸ್, ಏನೋ ಫಿಸಿಕಲ್ ಎಜುಕೇಶನ್, irrespective of your discipline, literature certainly will help you to take your students into confidence. ಯಾವ ತರ ಅಂತಂದ್ರೆ, ನೀವು ಲಿಟ್ರೇಚರ್ ಯಾವುದೇ ಒಂದು ಕಾನ್ಸೆಪ್ಟ್ ಹೇಳ್ಬೇಕಾದ್ರೆ ಲಿಟ್ರೇಚರ್ ಹೇಳ್ಕೊಂಡು ಹೋದ್ರೆ, ನೀವು ರವೀಂದ್ರನಾಥ ಟ್ಯಾಗೋರ್ ತರ್ಬೋದು, ಕುವೆಂಪು ಅವರ ಮಲೆನಾಡಿ ಮಲೆಗಳಲ್ಲಿ ಮದುಮಗಳು ತರ್ಬೋದು, ಅಥವಾ ಬೇರೆ ಯಾವುದಾದ್ರೂ ಆಗಿರ್ಬೋದು. ನೀವು ಭೈರಪ್ಪನವ್ರ ಕಾದಂಬರಿ ಓದೋಕೆ ನಿಮ್ಗೆ ಇಷ್ಟ ಇದ್ರೆ ಅಲ್ಲಿ ಬರ್ತಕ್ಕಂಥ ಸನ್ನಿವೇಶಗಳನ್ನ ತರ್ಬೋದು. ಯು ಕ್ಯಾನ್ ಕೀಪ್ ಯುವರ್ ಸ್ಟೂಡೆಂಟ್ಸ್ ಅಲೈವ್ ಅಂಡ್ ರಿಸೆಪ್ಟಿವ್. ಆ ರಿಸೆಪ್ಟಿವ್ ಆಗಿ ಇರಬೇಕು ಅವರು ಅಂತಂದ್ರೆ ಲಿಟ್ರೇಚರ್ ಹೆಲ್ಪ್ ಆಗುತ್ತೆ. ಓಕೆ, ಕಮ್ ಬ್ಯಾಕ್ ಟು ಅವರ್ ಡಿಸ್ಕಷನ್. ಲೆಟ್ ಮಿ ಡಿಸ್ಕಸ್ ಸಮ್ ಕೇಸ್ ಲಾಸ್, ಇಂಟ್ರೆಸ್ಟಿಂಗ್ ಕೇಸ್ ಲಾಸ್. The first and foremost public interest litigation was filed in the year 1979 before the Supreme Court. Hussain Ara cartoon series of cases. ಈ ಕೇಸಲ್ಲಿ ಆಗಿದ್ದಿಷ್ಟೇ, ಸಿಂಪಲ್ ಅದು. This petitioner approached the Supreme Court under Article 32, filing public interest litigation. He exposed in Bihar, as of now, ಸಾರಿ ಪ್ರದೀಪ್ ಅವರ ನಿಮ್ಮನ್ನು ಮ್ಯೂಟ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ ಪ್ಲೀಸ್. ಓಕೆ, ಇಲ್ಲಿ ಬಿಹಾರಲ್ಲಿ there are many under trials were there in jail, and also the prisoners were also there in the jail. There is a distinction between this prisoner and under trials. Prisoners yaru antandre those who have already been tried by the competent court of law and awarded punishment. They are undergoing sentence in the jail. They are called as prisoners. But whereas in case of under trials means those who are attending their hearing before court of law, bail sigde iroru, court ಮುಂದೆ ಈಗ ಹೋಗ್ತಾ ಇರೋರು ಇದಾರಲ್ಲ, they are called as under trials. ಕನ್ನಡದಲ್ಲಿ ಅವ್ರಿಗೆ ವಿಚಾರಣಾಧೀನ ಕೈದಿಗಳು ಅಂತ ಕರಿತೀವಿ. Those people are, they should not be allowed to mix together. There must be separate space for them. But here the jails were overcrowded. Both prisoners and under trials, they were grouped together. What happens in case if an under trial is allowed to mingle with a prisoner who is already undergoing sentence? He is already a criminal. He will teach these under trials how to become ಗುಡ್ ಕ್ರಿಮಿನಲ್ ಅಲ್ಲ. ಹಾಗಾಗಿ ನೀನ್ ನೋಡಪ್ಪ, ಕ್ರಿಮಿನಲ್ ಅಂತಂದ್ರೆ ಈ ತರ ಇರ್ಬೇಕು, ನನ್ ಟ್ಯಾಕ್ಟಿಸ್ ಈ ತರ, ನನ್ ಮೋಡಸ್ ಆಪರೆಂಡಿ ಈ ತರ ಅಂತ ಹೇಳಿ ಪೊಲ್ಯೂಟ್ ಮಾಡ್ತಾನೋ. ಬಟ್ ಏನಿಯೋ, ಈಗ there are some inhuman treatment meted out to these prisoners and under trials in prison. This authority brought it, this petitioner approached the Supreme Court, and Supreme Court found that more than 40,000 under trial prisoners are languishing in different jails in Bihar. 40,000 ಕೈದಿ, ಯಾರೋ ವಿಚಾರಣಾಧೀನ ಕೈದಿಗಳು ಜೈಲಿಂದ ಹೊರಗಡೆಗೆ ಬರದೆ 40,000 ಜನ ಇದ್ದಾರೆ ಜೈಲಿನಲ್ಲಿ ಇನ್ನೂನು ಅಂತ ಗೊತ್ತಾಯ್ತು ಅವ್ರಿಗೆ. Then the Supreme Court in a single stroke asked the state government to release all 40,000 under trial prisoners immediately. At least they have to be given bail. You are not supposed to keep them in jail without starting trial. Then in this case, the Supreme Court declared speedy trial is a fundamental right. ಶೀಘ್ರ ವಿಚಾರಣೆ ನಡೆಸ್ತಕ್ಕಂಥದ್ದು ಒಂದು ಫಂಡಮೆಂಟಲ್ ರೈಟ್ ಅಂತ ಡಿಕ್ಲೇರ್ ಮಾಡಿರೋದನ್ನ ನಾವು ನೋಡಬಹುದು. ವಿಚ್ ಮೀನ್ಸ್ ಥ್ಯಾಂಕ್ಸ್ ಟು ದಿಸ್ ಪೆಟಿಷನರ್, this speedy trial has become one of the fundamental rights and an important component under Article 21 of the Constitution. Next, let us go to SP Gupta versus Union. I am going to take a few cases. I think we have time till 3:10, correct? Yeah, 3 o'clock. Can anybody respond?
Yes, sir. Yes, sir.
3 ಗಂಟೆನಾ 3:10 ಎಷ್ಟು?
3:15.
3:15. Okay. Next to SP Gupta versus Union of India, an important case decided by the Supreme Court in the year 1982. This is popularly known as judges transfer case. Illi some advocates, they approached the Supreme Court regarding transfer of one High Court judge to another High Court, and appointment of High Court judges, and appointing them as additional judges. Then after appointing them as additional judges, some judges are made permanent upon completion of 1 year or 2 years of their additional judgeship post. And some of them are continued as 5 years without confirmation. Then the advocates, they questioned it before the court of law, stating that there is no uniformity here. These judges are under the mercy of the executive authority. ಅವರು ಜಡ್ಜ್ ಆಗಿ ಅಪಾಯಿಂಟ್ ಆಗಿರ್ತಾರೆ, ಅಡಿಷನಲ್ ಜಡ್ಜ್ ಆಗಿ ಕೆಲಸ ಮಾಡ್ತಾ ಇರ್ತಾರೆ, ಬೇರೆ ಕೋರ್ಟ್ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡ್ತೀರಿ, ಕನ್ಫರ್ಮ್ ಆಗಿರೋದಿಲ್ಲ, ಕೆಲವರು ಕನ್ಫರ್ಮ್ ಮಾಡ್ತೀರಿ, ಕೆಲವರು ಕನ್ಫರ್ಮ್ ಮಾಡೋದಿಲ್ಲ. ದೇರ್ ಇಸ್ ನೋ ಯೂನಿಫಾರ್ಮ್ ಪಾಲಿಸಿ ಇನ್ ದಿಸ್ ರೆಸ್ಪೆಕ್ಟ್. They questioned it before court of law. Then the question of locus standi, that is, by what authority you are questioning it before court of law, again comes before the court of law. Then after this, after hearing the parties, the Supreme Court declared that lawyers have every right to question these type of anomalies before the highest court of the land, that is the Supreme Court of India, because they are the affected persons. They are representing litigants. Hagagi, there must be a uniform policy. There must be a robust policy to make appointment to the judge, a judge's post. And it is also, you have to have a policy for their transfer, even for their promotion also. Then this clearly indicates that the people, those who are interested in these type of litigations, can approach court of law to get remedy. I would like to impress upon you with some other case laws. Do you know in one of the cases in 1980s, Supreme Court declared right to health as a fundamental right. Right to health as a fundamental right. This was thanks to a public spirited person called Ramchandra Katara. Ramanath Katara's case. In that case, this petitioner came to know that there was an accident in a public place. Where there was an accident, the driver of that vehicle did not stop his vehicle. It was a hit and run. Then the person who was badly injured, he went to the nearby doctor. Nearby doctor, he refused. He was a private doctor, refused to treat him. ಯಾವಾಗಲೂ ನಾವು ಆಕ್ಸಿಡೆಂಟ್ ಕೇಸ್ಗಳನ್ನ ಸಾಮಾನ್ಯ MLC ಅಂತ ಕರಿತೀವಿ, ನಮ್ಮ ಲೀಗಲ್ ಟರ್ಮಿನಾಲಜಿನಲ್ಲಿ ಮೆಡಿಕೋ ಲೀಗಲ್ ಕೇಸಸ್ ಅಂತ ಕರಿತೀವಿ, ಅದಕ್ಕೆ MLC ಅಂತ ಶಾರ್ಟ್ ಆಗಿ ಕರಿತೀವಿ. ಅಲ್ಲೇನಂದ್ರೆ ಈ ಮೆಡಿಕಲ್ ಲೀಗಲ್ ಕೇಸ್ ಅಟೆಂಡ್ ಮಾಡಿದ್ರೆ ಸಾಕ್ಷಿ ಹೇಳೋಕೆ ಹೋಗ್ಬೇಕಾಗುತ್ತೇನೋ ನಾನು ಅಂತ ಇವ್ರಿಗೆ. ಹಾಗಾಗಿ ಸಾಮಾನ್ಯವಾಗಿ ಇಲ್ಲೇನಾಯ್ತು, ದ ಡಾಕ್ಟರ್ ರೆಫ್ಯೂಸ್ ಟು ಟ್ರೀಟ್. ದೆನ್ ಈ ವೆಂಟ್ ಟು ದ ತಾಲೂಕ್ ಹಾಸ್ಪಿಟಲ್. ತಾಲೂಕ್ ಹಾಸ್ಪಿಟಲ್ ಡಾಕ್ಟರ್ ರೆಫ್ಯೂಸ್ ಟು ಅಡ್ಮಿಟ್ ಹಿಮ್ ಬಿಕಾಸ್ ವಿ ಹ್ಯಾವ್ ನೋ ಬೆಡ್ಸ್ ಹಿಯರ್. ದೇರ್ ಇಸ್ ನೋ ವೇಕೆಂಟ್ ಬೆಡ್ ಹಿಯರ್. ಇಲ್ಲಪ್ಪ, ಹಾಸಿಗೆ ಇಲ್ಲ, ನಾನು ನಿನ್ನ ಸೇರಿಸ್ಕೊಳ್ಳೋಕೆ ಆಗೋದಿಲ್ಲ. ಈ ವೆಂಟ್ ಟು ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಹಾಸ್ಪಿಟಲ್, ದ ಸೇಮ್ ಥಿಂಗ್. He was forced to join some other hospital. You see, during hospital, some golden hour is there. Within the golden hour, it is the responsibility of the doctor to treat him, or he has to approach the correct, the specialist to save his life. Then here in this case, he brought it to the notice of the court that he went to pillar to post. Then the private doctor refused to treat him. The Supreme Court took cognizance of that particular matter, and they took him to task. Even though you are a doctor, you being a doctor have sworn in the name of what you call it, Hippocrates oath, we call it as, because he is considered as a father of medical science. You take oath. While taking oath, your oath is you are subscribing to in the name of God that you are going to save the life of a person when who approaches him. Even though you may not be an expert, you are not be a specialist, you have no facility at the time of treating him, but being a doctor, at least it is your responsibility to attend the patient and to administer first aid. ಅಲ್ಲಪ್ಪ, ನಿನ್ನ ಹತ್ರ ನಾನು ಸ್ಪೆಷಲಿಸ್ಟ್ ಅಲ್ಲ, ತಲೆಗಾಯ ಆಗಿದೆ, ನಾನು ಸ್ಪೆಷಲಿಸ್ಟ್ ಅಲ್ಲ ಅಂತ ಹೇಳ್ಬೋದು ನೀನು. ಆದ್ರೆ ಡಾಕ್ಟರ್ ಆಗಿ ಫಸ್ಟ್ ಏಡ್ ಆದ್ರೂ ಕೊಡ್ಬೋದಾಗಿತ್ತಲ್ಲ ನೀನು. ಅಟ್ಲೀಸ್ಟ್ ಫಸ್ಟ್ ಏಡ್ ಕೊಟ್ಟು ನೀನು ಅಟೆಂಡ್ ಮಾಡಿದ್ರೆ ಅವನು ಇನ್ನೊಂದು ಆಸ್ಪತ್ರೆಗೆ ಹೋಗುವಷ್ಟರಲ್ಲಿ ಅವ್ನ ಜೀವ ಉಳ್ಕೊಳ್ತಾರ. ಹಾಗಾಗಿ ಈಸ್ ಇಟ್ ನಾಟ್ ಯುವರ್ ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟಿ ಟು ಟ್ರೀಟ್ ದ ಪೇಷಂಟ್? Then in this case, the Supreme Court took cognizance of the matter and made Medical Council of India as a party and directed Medical Council of India to circulate this judgment to all the doctors, those who are registered under Medical Council of India. In case of any dereliction of duty by any doctor will be treated as breach of professional ethics and they are liable to be shunted out. They have to be removed from practice. ರೋಲ್ಸ್ ಆಫ್ ಪ್ರಾಕ್ಟೀಸ್. ಅವ್ರಿಗೆ ಅವ್ರು ಎನ್ರೋಲ್ ಮಾಡಿಸ್ಕೊಂಡಿರ್ತಾರಲ್ಲ, ಅವ್ರೇನಾದ್ರು ಡೆರಿಲಿಕ್ಷನ್ ಆಫ್ ಡ್ಯೂಟಿ ಅಟೆಂಡ್ ಮಾಡಲಿಲ್ಲ ಅಂತ ನೋಡಿ, ಅದು ಒಬ್ಬ ವ್ಯಕ್ತಿಯಿಂದ ಒಬ್ಬ ವ್ಯಕ್ತಿ ಒಂದು ಪಬ್ಲಿಕ್ ಇಂಟ್ರೆಸ್ಟ್ ಲಿಟಿಗೇಷನ್ ಹಾಕೊಂಡಿದ್ರಿಂದ ಏನಾಯ್ತು, ದ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಡಿಕ್ಲೇರ್ಡ್ ದ ರೈಟ್ ಟು ಹೆಲ್ತ್ ಆಸ್ ಎ ಫಂಡಮೆಂಟಲ್ ರೈಟ್ under Article 21 of the Constitution. What Article 21 of the Constitution says? Article 21 declares that no person shall be deprived of his right to life or personal liberty except in accordance with the procedure established by law. ಕನ್ನಡದಲ್ಲಿ ಹೇಳ್ಬೇಕಾದ್ರೆ, ಯಾವುದೇ ಒಬ್ಬ ವ್ಯಕ್ತಿಯ ಜೀವಿಸುವ ಮತ್ತು ವೈಯಕ್ತಿಕ ಸ್ವಾತಂತ್ರ್ಯವನ್ನು ಕಾನೂನಿನ ಬೆಂಬಲವಿಲ್ಲದೆ ಅಥವಾ ಕಾನೂನಿನ ಪ್ರಕ್ರಿಯೆಗಳಿಗೆ ಅನುಗುಣವಾಗಿ ಅಲ್ಲದೆ ಹರಣ ಮಾಡುವಂತಿಲ್ಲ ಅಂತ ಆರ್ಟಿಕಲ್ 21 ಹೇಳುತ್ತೆ. Article 21 includes, in the opinion of Supreme Court, the right to health. ಏನ್ ಬೇಕು ಒಬ್ಬ ಮನುಷ್ಯನಿಗೆ ಬದುಕೋಕೆ, and not merely providing him the food, clothing and shelter. What he requires to lead his life, he requires something more. What it is? That is health. You have to provide him health facility and you have to provide him education. And also Supreme Court went to the extent of declaring that right, it is right to get pollution-free water and air is also a fundamental right. Paramananda Katara's case stands tall because of the reason that he is the person who argued before the court of law that a person cannot enjoy his life without good health. And it is the responsibility of the state to provide the minimum health facility. In this case, Supreme Court declared right to health as a fundamental right. Next, let me pass on to another important area where some public spirited persons are approaching court of law on behalf of all of us. We are not approaching court of law, but there are some public spirited persons are there. They are fighting for us. One such person is MC Mehta, a designated senior advocate practicing in Supreme Court of India. MC Mehta is awarded with alternate Nobel Prize also for his continuously pursuing public interest litigation to protect environment. He is the person who is responsible for cleaning of Ganga River. Now, cleaning of Ganga River is the mission of the present government. They are spending crores of rupees thanks to MC Mehta series of cases. MC Mehta, he approached the Supreme Court through a public interest litigation. And he brought it to the notice of the Supreme Court that on the banks of river Ganga, there are many polluted industries are there. They are discharging pollutants, untreated water or the waste, industrial waste into Ganga River. The Ganga River is considered as ನಾವೆಲ್ಲರೂ ತುಂಬಾ ಪವಿತ್ರವಾದದ್ದು. ಇಟ್ಸ್ ಅ ಸೇಕ್ರೆಡ್ ರಿವರ್ ಇನ್ ಅವರ್ ಒಪಿನಿಯನ್. ಅಲ್ಲಿ ಹೋಗಿ ಸ್ನಾನ ಮಾಡಿದ್ರೆ ನಮಗೆ ಎಲ್ಲ ಪಾಪಗಳು ಕಳೆದೋಗುತ್ತೆ ಅಂತ ಹೋಗಿ ಒಂದೇ ಸಲ ನಿನ್ನೆ 30-40 ಜನ ಸ್ವರ್ಗ ಸೇರ್ಕೊಂಡ್ರು. ಇರ್ಲಿ, ಅದು ಡಿಫ್ರೆಂಟ್ ಥಿಂಗ್. ಏನು ಫ್ರೆಂಡ್ಸ್, ಇಲ್ಲಿ it is supposed to be a sacred river, but it is being polluted. If the rivers are polluted, what happens? If the rivers are polluted, then they all aquaculture there. They will be spoiled. And then we are using river water to grow food. That is also being polluted. It will have its cascading effect on the health of individuals. Then the it is the responsibility of the state to ensure that the river shall not be polluted. Here, in this case, the Supreme Court imposed several crores of rupees as penalty on the industrialist, those who discharge their effluents without treating the industrial waste to the Gangetic River. And he is the person one who is responsible. I am going to tell you how some of the concept or the doctrines have been evolved by the Supreme Court thanks to these type of MC Mehta series of cases and other cases. Friends, polluter pays principle is being adopted by the Supreme Court thanks to this public interest litigation. What is this polluter pays principle? You are a polluter, you are an industrialist, you are polluting the environment. It is your responsibility to have a precautionary measure, correct? You have to have a precautionary measure. Take, for example, in Mandya, we have Mandya Sugar Factory. Mandya Sugar Factory, they discharge effluents and all the dust particles are spread across 12 kilometers. The people in and around Mandya city and nearby villages, they are having some breathing problems and lung respiratory problems and other things. Then in such circumstances, is it not your responsibility to have dust catcher there? ನೀವು ಹೊಗೆ ಹೋಗೋ ಜಾಗದಲ್ಲಿ ಡಸ್ಟ್ ಕ್ಯಾಚರ್ ಇಟ್ಕೊಂಡು ಅದನ್ನು ಕ್ಲೀನ್ ಮಾಡೋದು ನಿಮ್ ಜವಾಬ್ದಾರಿ ಅಲ್ವಾ ಅದು? That is called precautionary principle. Our Supreme Court declared that precautionary principle is one of the essential thing to prevent environment pollution. Second one is polluter pays principle. You have already polluted environment for which you have to pay penalty to repair it. Now we have in other concept we call it as corporate social responsibility. ಈಗ ಕಾರ್ಪೊರೇಟ್ ಸೋಷಿಯಲ್ ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟಿ ಅಂತ ಕರೀತೀವಿ. ಯು ಆರ್ BMTC ಬಸ್ ಇನ್ ಬ್ಯಾಂಗ್ಳೂರ್ ಆರ್ KSRTC, ಯು ಆರ್ ಪೊಲ್ಯೂಟಿಂಗ್ ಎನ್ವಿರಾನ್ಮೆಂಟ್. ವಾಟ್ ಹ್ಯಾವ್ ಯು ಡನ್ ಫಾರ್ ಅಫಾರೆಸ್ಟೇಷನ್? You have to give money to the government. Government will give it to some NGOs. NGOs will take sapling of plants. At least ಗಿಡ ನೆಡೋದು, ಸಸಿ ನೆಡೋ ಕಾರ್ಯಕ್ರಮನ ಅವ್ರು ಇಟ್ಕೊಂಡಿರ್ತಾರೆ. ಅದರಿಂದ ಎನ್ವಿರಾನ್ಮೆಂಟ್ ಪೊಲ್ಯೂಟ್ ಆಗೋದನ್ನ ತಡಿಬೋದಲ್ಲ ನಾವು. ಅದಕ್ಕೆ ನೀನ್ ದುಡ್ಡು ಕೊಡು. ಪೊಲ್ಯೂಟರ್ ಪೇಸ್ ಪ್ರಿನ್ಸಿಪಲ್ ವಿ ಕಾಲ್. Public trust doctrine is one of the important doctrine evolved thanks to this public interest litigation. ಏನಿದು public trust doctrine ಅಂತಂದ್ರೆ, today's the environment what we are living, it is not our own property. Even it belongs to our future generation. ನಮ್ಮದು ಮಾತ್ರ ಅಲ್ಲ ಅದು. ಇನ್ನು ಮುಂದೆ ಬರ್ತಕ್ಕಂಥ ಜನಾಂಗಕ್ಕೂ ನಾವು ಏನಾದ್ರೂ ಒಳ್ಳೇದನ್ನ ಇಲ್ಲಿ ಬಿಟ್ಟು ಹೋಗ್ಬೇಕು. ನಾವು ಪೊಲ್ಯೂಟ್ ಮಾಡಿ ಹೋದ್ರೆ ಆ ಮಕ್ಕಳುಗಳು ಏನ್ ಮಾಡ್ಬೇಕು? ದೇ ಹ್ಯಾವ್ ಟು ಕ್ಯಾರಿ ಆಕ್ಸಿಜನ್ ಬ್ಯಾಗ್ಸ್ ಆನ್ ದೇರ್ ಬ್ಯಾಕ್. ದಿಸ್ ಈಸ್ ದ ಸಿಚುಯೇಷನ್ ವಿ ಆರ್ ಗೋಯಿಂಗ್ ಟು ಕ್ರಿಯೇಟ್. ದೆನ್ ಇನ್ ಸಚ್ ಸರ್ಕಮ್ಸ್ಟೆನ್ಸಸ್ ದ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ರಿಮೈಂಡ್ ಅಸ್ ದಟ್ ವಿ ಆರ್ ಆಲ್ ಟ್ರಸ್ಟೀಸ್ ಆಫ್ ದಿಸ್ ಎನ್ವೈರನ್ಮೆಂಟ್. ಇದು ಎಲ್ರಿಗೂ ಸೇರಿದ್ದು. ಇದನ್ನ ಪ್ರೊಟೆಕ್ಟ್ ಮಾಡ್ತಕ್ಕಂಥದ್ದು ನಮ್ಮೆಲ್ರೂ ಕರ್ತವ್ಯ. ನಮಗ್ ಬರೀ ಹಕ್ಕಿದೆ ಅಂತ ಹೇಳೋದು ಅಷ್ಟೇ ಅಲ್ಲ, ಇದನ್ನ ಪ್ರೊಟೆಕ್ಟ್ ಮಾಡ್ತಕ್ಕಂಥ ಕರ್ತವ್ಯನೂ ನಮಗಿದೆ ಅಂತ ಹೇಳ್ತಕ್ಕಂಥ ಮಾತನ್ನ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಯಾವ ಪ್ರಕರಣದಲ್ಲಿ ಹೇಳ್ತಾರೆ ಹೇಳ್ತೀನಿ ನಿಮ್ಗೆ ಅದನ್ನ. ಕಮಲ್ನಾಥ್ ವರ್ಸಸ್ ಯೂನಿಯನ್ ಆಫ್ ಇಂಡಿಯಾ ಇಸ್ ಒನ್ ಸಚ್ ಕೇಸ್. ಈ ಕೇಸಲ್ಲಿ ಏನಾಯ್ತು, ಇನ್ ಮಧ್ಯಪ್ರದೇಶ್ ಇನ್ ಅ ಡೆನ್ಸ್ ಫಾರೆಸ್ಟ್, dense forest, one politician wanted to build a 5-star hotel right in the middle of a river, altering the river course. ಅವ್ರಿಗೆ ಅದೇನು ಅನಿಸ್ತೋ ಗೊತ್ತಿಲ್ಲ, ಒಂದು 5-star ಹೋಟೆಲ್ ಕಟ್ಟಬೇಕು ಅಂತ ಅನಿಸ್ತು. ಎಲ್ಲಿ ಕಟ್ಟಬೇಕು? ನದಿ ಮಧ್ಯದಲ್ಲಿ ಕಟ್ಟಿದ್ರೆ ನದಿ ನೀರು ಆ ಕಡೆ ಈ ಕಡೆ ಬರ್ಬೇಕದು. ಈ ವಾಂಟೆಡ್ ಟು ಆಲ್ಟರ್ ದ ರಿವರ್ ಕೋರ್ಸ್ ಅಂಡ್ ದೆನ್ ಅಲ್ಲಿಗೆ ಟು ಅಪ್ರೋಚ್ ದಟ್ ಪರ್ಟಿಕ್ಯುಲರ್ ರಿವರ್ ಯು ಹ್ಯಾವ್ ಟು ಕಟ್ ಆಫ್ thousands of trees. Now, the Environment Department has given their clearance to cut off trees, and also the concerned authorities gave him the license to build a hotel. When it was brought to the notice of the Supreme Court took all the authorities to task and saying that we are all trustees of the property. You are in a position, you are in administrative position. You are a lawmaker. You treat yourself as a trustee of environment. Don't violate it. And this environment, this one is belong not only to the present generation, it is to the future generation also. And then in some other circumstances also, in MC Mehta series of cases, friends, our Supreme Court ordered for closing down of several industries polluting close by Taj Mahal in Agra. And also it has ordered for closure of several industries in Delhi because Delhi is already a polluted city. Likewise, this public interest litigation is helped us, in fact, to protect environment. There are many other situations. I can quote thousands of cases in this respect. I'm going to take up some of the case laws in the next session. Friends, however, what are the contribution of this public interest litigation? The contribution of this public interest litigation is mainly access to justice. Access to justice. As we have already discussed, the getting justice is a laborious task. In India, we have to hire best brains, best lawyer. We have to pay money. We have to pay court fee. Then in such circumstances, can a poor man approach court of law? And in this respect, our Supreme Court in one case, that is MH Vascourt versus State of Maharashtra in the year 1983, declared free legal aid as a fundamental right. Free legal aid as a fundamental right. Then what is this free legal aid? A person who has no money, he can't be go unrepresented before court of law. He must be provided with a lawyer by the state. Even a declared terrorist, ಯಾರು ಪಾಕಿಸ್ತಾನದಿಂದ ಬಂದು ಅವನ ಹೆಸರೇನು ತಾಜ್ ಹೋಟೆಲ್ ನಲ್ಲಿ ಇದ್ ಮಾಡಿದ್ನಲ್ಲ ಅವನು ಸುಮಾರು ಜನ ಕಸಬ್ ಕೇಸ್. Even in Kasab case also, what we have done, we have gave him a lawyer. Why? Because the court has to take considered decision. To take considered decision, a person cannot go unrepresented by a lawyer. That's why we have, in this case, Supreme Court declared that the free legal aid for a poor and indigenous is their fundamental right. Poor and indigenous ಅಂತಂದ್ರೆ ಯಾರು ಬಡವರು ಇರ್ತಾರೋ, ಯಾರು ಬೇರೆ ಯಾವುದೇ ಆದಾಯದ ಮೂಲಗಳಿಲ್ಲದೆ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಬರ್ತಾರೋ ಅಂತವ್ರಿಗೆ ಇಟ್ ಇಸ್ ದ ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟೀಸ್ ಆಫ್ ದ ಸ್ಟೇಟ್ ಟು ಪ್ರೊವೈಡ್ ದೆಮ್ ಎ ಲಾಯರ್. ಹೌದು, ನಾವು ಕೊಡ್ತಾ ಇದ್ದೀವಿ. ಲೋಕ ಅದಾಲತ್ ಮಾಡ್ತೀವಲ್ಲ ನಾವು, ಲೀಗಲ್ ಸರ್ವಿಸಸ್ ಅಥಾರಿಟಿ. ಈಗ ನೀವೆಲ್ಲರೂ ಯು ಆರ್ ಗೋಯಿಂಗ್ ಟು ಜಾಯಿನ್ ಯುವರ್ ಡ್ಯೂಟಿ. ಇಟ್ ಈಸ್ ಯುವರ್ ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟಿ ಟು ಇಂಪ್ರೆಸ್ ಅಪಾನ್ ಯುವರ್ ಸ್ಟೂಡೆಂಟ್ಸ್ to participate in legal awareness programs and also to organize Lok Adalat where the disputes could be solved through negotiation. It is a win-win situation for everybody. ಅಲ್ಲಿ ನೆಗೋಸಿಯೇಷನ್ ಮಾಡೋದ್ರ ಮುಖಾಂತರ ಕೋರ್ಟ್ಗೆ ಹೋದ್ರೆ ಒಬ್ಬ ಸೋಲ್ತಾನೆ, ಒಬ್ಬ ಗೆದ್ರೆ ಇನ್ನು ಉಳಿದವ್ರು ಸೋಲ್ಲೇಬೇಕಾದ್ರಲ್ಲಿ. ಆದ್ರೆ ಇಲ್ಲಿ ಏನಾಗುತ್ತೆ, ಲೋಕ ಅದಾಲತ್ತಲ್ಲಾದ್ರೆ ಅಥವಾ ನಾವು ಲೋಕ ಅದಾಲತ್ತಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ ಮಾಡೋದಾದ್ರೆ ಅಲ್ಲಿ ಯಾರು ಸೋಲೋದಿಲ್ಲ, ಯಾರು ಗೆಲ್ಲೋದಿಲ್ಲ. ಇಟ್ಸ್ ಎ ವಿನ್-ವಿನ್ ಸಿಚುಯೇಷನ್ ಫಾರ್ ದ ಸ್ಟೇಟ್, ಫಾರ್ ದ ಕೋರ್ಟ್, ಇಟ್ ಈಸ್ ಫಾರ್ ದ ಪೊಲೀಸ್, ಇಟ್ ಈಸ್ ಫಾರ್ ದ ಪಾರ್ಟೀಸ್ ಆಲ್ಸೋ. ಅಂಡ್ ದೆನ್ ವಾಟ್ ಈಸ್ ದ ಒಪಿನಿಯನ್ ಆಫ್ ದ ಕೋರ್ಟ್ ಈಸ್ ದಿಸ್: free legal aid is a fundamental right of a poor and indigent. Then the state has to provide him. A person is not represented by a lawyer cannot go directly to the jail, and it is the responsibility of the magistrate to provide him a legal practitioner to assist him and to help him. Likewise, friends, this public interest litigation has brought in several changes in the administration of justice. And also another important aspect is that the public interest litigation is helped us to at least to minimize corruption and to bring in good governance. Where there is nepotism, then the people approach court of law. Nepotism means ಏನಂತೀವಿ ನಾವು, ಅವ್ರ ಮನೆಯವ್ರಿಗೆ, ಅವ್ರ ಅಣ್ಣ ತಮ್ಮಂದ್ರಿಗೆ ಕಾಂಟ್ರಾಕ್ಟ್ ಕೊಟ್ಕೊಳ್ಳೋದು, ಈ ತರ ಏನೋ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಲ್ಯಾಪ್ಸಸ್ ಇರುತ್ತಲ್ಲ, ಆ ತರದ್ದೆಲ್ಲ ಸ್ವಜನ ಪಕ್ಷಪಾತ ಅಂತ ಕರಿತೀವಿ ಕನ್ನಡದಲ್ಲಿ. ಇನ್ ಸಚ್ ಸರ್ಕಮ್ಸ್ಟೆನ್ಸಸ್ ಸಚ್ ಆಸ್ಪೆಕ್ಟ್ಸ್ ದಿ litigated through public interest litigation and the court will look into it. And the many other cases, this public interest litigation bring in transparency in public administration, because the officials are aware of this particular thing. Certainly, they know that anything wrong committed, it will be questioned before court of law. Then what are the flip side of this public interest litigation? This public interest litigation has become, for somebody, a political interest litigation. For somebody, it is a popularity interest litigation. For someone, it is a publicity interest litigation. It is a flip side of public interest litigation. ಕೆಲವರಿಗೆ ರಾಜಕೀಯ ಕಾರಣಗಳಿಗಾಗಿ ಮಿಸ್ಯೂಸ್ ಮಾಡ್ಕೊಳ್ತಾ ಇರೋದು ಉಂಟು ಕೂಡ ಇದನ್ನ. ಮತ್ತೆ ಕೆಲವರು ಈ ಪಬ್ಲಿಕ್ ಇಂಟ್ರೆಸ್ಟ್ ಲಿಟಿಗೇಷನ್ ನ ತಮ್ಮ ಪ್ರಚಾರಕ್ಕೋಸ್ಕರವಾಗಿ ಬಳಸ್ಕೊತಾ ಇರೋದನ್ನು ನಾವು ನೋಡಬಹುದು. ಈ ತರದ ಕೆಲವೊಂದಷ್ಟು ಇರಬಹುದು, ನಿಜ. People from Karnataka, they are aware. Yesterday, Supreme Court took to task the counsel of Basavaraj Patil Yatnal, one who questioned D.K. Shivkumar case before the Supreme Court. ಇಲ್ಲಿ ಏನಾಯ್ತು, ಯತ್ನಾಳ್ ಅವ್ರ ಪ್ರಶ್ನೆ ಇಷ್ಟೇ, ಹಿಂದೆ ಬಿಜೆಪಿ ಗವರ್ಮೆಂಟ್ ಇದ್ದಾಗ ಡಿ ಕೆ ಶಿವಕುಮಾರ್ ಅವ್ರ ವಿರುದ್ಧ ಇದ್ದಂತ ಪ್ರಕರಣವನ್ನ ಸಿಬಿಐಗೆ ವಹಿಸಿದ್ರು. ಈ ಸರ್ಕಾರ ವಾಪಸ್ ತಗೊಂಡಿದ್ದಾರೆ ಸಿಬಿಐ ಇಂದ. ಸಿಬಿಐಯು ಕ್ವಶನ್ ಮಾಡಿದ್ದಾರೆ ಅದನ್ನ. ಬಸವನಗೌಡ ಪಾಟೀಲ್ ಯತ್ನಾಳ್ ಅವರು ಕೂಡ ಪ್ರಶ್ನೆ ಮಾಡಿದ್ದಾರೆ. ಆದ್ರೆ ಸಿಬಿಐನವ್ರಿಗೆ ಈ ಪ್ರಶ್ನೆ ಕೇಳಿಲ್ಲ ನಿನ್ನೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್. ಯತ್ನಾಳ್ ಅವ್ರಿಗೆ ಏನ್ ಕೇಳಿದೆ, ಯು ಆರ್ ಎ ಪೊಲಿಟಿಷಿಯನ್, ಯು ಆರ್ ಯೂಸಿಂಗ್ ಇಟ್ ಆಸ್ ಅ ಪೊಲಿಟಿಕಲ್ ಟೂಲ್ ಅಲ್ಲ, ಹಾಗಾಗಿ ಯು ಆರ್ ನಾಟ್ ಸಪೋಸ್ ಟು ಅಪ್ರೋಚ್ ಅಸ್. ಹಾಗೆ ಮತ್ತೆ ಇನ್ನೊಂದು, ಲೆಟ್ ಮಿ ಟೆಲ್ ಯು ಒನ್ ಇಂಪಾರ್ಟೆಂಟ್ ಇನ್ಸಿಡೆಂಟ್ ಹೌ ದ ಪಬ್ಲಿಕ್ ಇಂಟ್ರೆಸ್ಟ್ ಲಿಟಿಗೇಷನ್ಸ್ ಆರ್ ಬೀಯಿಂಗ್ ಮಿಸ್ಯೂಸ್ಡ್. When H.D. Devegowda was the chief minister in Karnataka, one Mr. Anand, who was last election against H.D. Devegowda from Ole Narsipura constituency, he filed a public interest litigation making allegation against Devegowda, chief minister, that he is indulging in seconds and bottling scam. ಯಾವುದು ಬಾಟ್ಲಿಂಗ್ ಸ್ಕ್ಯಾಮ್ ಅಂತ ಹೇಳಿ ಅದರಲ್ಲಿ ಅವ್ರು ಇನ್ವಾಲ್ವ್ ಆಗಿದ್ದಾರೆ ಅಂತೇಳಿ. ಸೊ ದಿ ಹೈಕೋರ್ಟ್, ಕರ್ನಾಟಕ ಹೈಕೋರ್ಟ್ ಫೌಂಡ್ no merit in the case and imposed 10,000 rupees as penalty on the person who filed frivolous public interest litigation. Likewise, there are some people, they are misusing public interest litigation. That's why, taken that into consideration, what Supreme Court is done now is this. ಮೊದಲೆಲ್ಲ ಏನ್ ಮಾಡೋರು ಜನ ಅಂದ್ರೆ, ಪಬ್ಲಿಕ್ ಇಂಟ್ರೆಸ್ಟ್ ಲಿಟಿಗೇಷನ್ ಹಾಕೊಳ್ಳೋರು, ಒಂದಷ್ಟು ನೆಗೋಷಿಯೇಟ್ ಮಾಡಿ ಅವ್ರ ಹತ್ರ ದುಡ್ಡು ತಗೊಂಡು ಏನೋ ಅದನ್ನ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಾ ಇರ್ಲಿಲ್ಲ. ಈಗ ಆತರ ಇಲ್ಲ. Once a public interest litigation is filed, it will be treated as a public interest litigation filed by a person, and it is the responsibility of the court to pursue the matter further. Even though petitioner goes back, ಅವನು ವಿತ್ಡ್ರಾ ಮಾಡ್ಕೊಂಡ್ರು, ಇಲ್ಲ ಸ್ವಾಮಿ ನಾನು ಕೇಸ್ ನಡೆಸಲ್ಲ, ನನ್ನ ಕೈನಲ್ಲಿ ಆಗಲ್ಲ ಅಂದ್ರೂ, the court will continue such public interest litigation. They will not allow the petitioner to withdraw. ಯಾಕೆ ಅಂತಂದ್ರೆ, ಪಬ್ಲಿಕ್ ಇಂಟ್ರೆಸ್ಟ್ ಲಿಟಿಗೇಷನ್ ಹಾಕೋದು ಮೊದಲಿನಷ್ಟು ಈಸಿ ಅಲ್ಲ. ಈಗ ಪಬ್ಲಿಕ್ ಇಂಟ್ರೆಸ್ಟ್ ಲಿಟಿಗೇಷನ್ ಹಾಕಿದ್ರೆ ಪರ್ಸ್ಯೂ ಮಾಡಬೇಕು. ಇನ್ ಕೇಸ್ ಇಫ್ ಯು ಕುಡ್ ನಾಟ್ ಏಬಲ್ ಟು ಪರ್ಸ್ಯೂ, ದ ಕೋರ್ಟ್ ವಿಲ್ ಡೈರೆಕ್ಟ್ ದ ಲೀಗಲ್ ಸರ್ವಿಸಸ್ ಅಥಾರಿಟಿ ಟು ಬಿಕಮ್ ಎ ಪಾರ್ಟಿ ಅಂಡ್ ಟು ಕಂಟಿನ್ಯೂ ದ ಕೇಸ್. ಹಾಗಾಗಿ, ಟು ಮಿನಿಮೈಸ್ ದ ಇಲ್ ಎಫೆಕ್ಟ್ಸ್ ಆಫ್ ದಿಸ್ ಪರ್ಟಿಕ್ಯುಲರ್ ಪಬ್ಲಿಕ್ ಇಂಟ್ರೆಸ್ಟ್ ಲಿಟಿಗೇಷನ್ and misuse of public interest litigation, our courts have evolved some mechanism, and one such mechanism is this: the public interest litigation petitions have to be heard only in portal number 1, that is headed by the Chief Justice of India, or in other senior judges, a bench constituted and designated by the Chief Justice of India or the respective high courts, Chief Justices of the respective high courts, and not individual judge can entertain such things. Only the portal number 1, a bench headed by the Chief Justice of India, or any other bench constituted and entrusted that responsibility by the Chief Justice of India or the respective High Court Chief Justices. This is about the public interest litigation. I think it is 3:10 now. You will have an opportunity now to interact. It is the time for question and answer. And you can express your opinion also, not necessarily question. please unmute and you can raise any question. Or if you want any clarification, feel free. Or if you want to add something to my lecture now, you can also welcome.
Good afternoon, sir.
Good afternoon, sir. Tell me, sir.
Sir, this is Ponappa. You had been telling that anyone who is a poor, who is not able to afford for lawyer is provided
Yes.
by the government.
Yes.
That point can be understood, sir.
Yes.
Because a person who is not affordable can. But what happened in the case of that 2611? Do you think it's the right thing?
Yes. Being a lawyer, it's my sincere opinion that our judicial system is so robust. And in the international community, everyone appreciated India because even though he is an alien enemy, he was provided the fair hearing. We call it as fair hearing. Before the court of law, one cannot be shunted out. One cannot be sent out mercilessly without hearing him. We heard him. ಏನಾಯ್ತು ಗೊತ್ತಾ ಇದು ಆ ಕೇಸಲ್ಲಿ ಒಪ್ಪನಪ್ಪನವ್ರೆ? In that case, when he was allowed to hire, they asked him, have you hired an advocate ಅಂತ ಕೇಳ್ತಾರೆ. That man said no. Okay, we are ready to give you a panel of advocates because it is not his right to claim that he has to be represented only by Anil Diwan, only by Kapil Sibal, or designated senior advocate. ಆತರ ಅಲ್ಲ. There is a panel of advocates in that particular court, among whom you can choose. You can choose somebody. But that fellow, what he did, I want an advocate to represent me from Pakistan. And then the court rejected it. No, that cannot happen. Only we provide you a lawyer in Bombay, because he was tried before a Bombay court. Then he was given an advocate was representing him, and he made a good case, yes, on behalf of Abdul Qasem, whatever it may be. He tried his level best. And then the international, because ours is not a theistic state, ours is a democratic state, where administration of justice is not only be done. Justice is not only be done, it should be manifestly and undoubtedly seen to be done. ಅದು ನಮ್ಮ ಸಿಸ್ಟಮ್ನ ಮೂಲ ಅದೇನೆ. ಕೇವಲ ನ್ಯಾಯ ನಿರ್ಣಯ ಮಾಡಿದರೆ ಸಾಲದು. ಮಾಡಿರುವ ನ್ಯಾಯ ನಿರ್ಣಯವು ಸಂಶಯಾತೀತವಾಗಿರಬೇಕು. ಕೇವಲ ನ್ಯಾಯ ನಿರ್ಣಯ ಮಾಡಿದ್ರು ಸಾಲದು, ನ್ಯಾಯ ನಿರ್ಣಯ ಮಾಡಿರುವುದು ಸಮರ್ಪಕವಾಗಿರಬೇಕು. When we say it is undoubtedly and manifestly to be done, then these type of measures are necessary. Okay? Yes, this is my considered opinion.
Yes, sir. Thank you, sir.
Yes, thank you. Any other question? ಕೇಳಿ, ಪರವಾಗಿಲ್ಲ.